Hello, everyone. Welcome to another session of Law and Policy Discussions. And today we'll be discussing recent information technology based laws and their implications on the uh, uh, right to privacy and freedom of speech. The laws that were approved by the cabinet, of course, they are still bills, they are not laws. Uh, they deal with access and storage of personal data and control of content on social media. So, of course, we'll be discussing these laws in light of the Constitution of Pakistan, as well as international law and international best practices. Right? So, you guys can take over.
My name is Mohammad Farishwar, and I am a senior year law student at Lahore University of Management Sciences and a research associate at RCIL and HR. So, as sir mentioned, that recently the former opposition-led government of Pakistan recently passed a few legislations, namely the Personal Data Protection Bill 2023, E-Safety Bill 2023, and it set out some amendments in the Prevention of Electronic Crimes Act 2016. But these legislations didn't get assent of the prime president, and their conversion and the conversion of these bills to laws has been deferred till the holding of the next elections. But despite that, these proposed legislations have been greatly criticized by the human rights activists and the lawyers of the country. There are certain reasons, for instance, these bills are greatly criticized because they lack transparency. They provide the mass surveillance to the government over the digital assets of the individuals, and obviously they infringe on the fundamental rights of the citizens, like freedom of speech and the privacy of the individuals. So here first we have PECA Amendment Bill 2023. PECA, as we already know, that it was enacted in 2016, and since its inception, it has been used as a tool to infringe on the basic rights of the journalists and activists, and various times they have been tried under this act. So later in 2022, the scope of this act was widened through the PECA Ordinance 2022, as it has been mentioned here that its scope was broadened to criminal defamation with the intention to insulate state institutions from criticism on the social media. But in the same year, this ordinance was struck down by Islamabad High Court. And now, as we are in 2023, there has been another amendment with the addition of Section 20A of the PECA Act. So the section, the newly added section says that any person who shares fake or false information will be convicted for 5 years in the prison. So this section requires much attention, as the language of this section is very vague. So basically, who will decide what is the fake or false information, right? Generally, no specific definition has been provided in the act, and no specific definition has been provided in this act specifically. So, for instance, if anybody who criticizes on any of the dubious policies of the state on any of the platforms of social media, he might be convicted under this proposition, right? And he might be convicted of being sharing this false or fake information. So, moreover, this section states that the proposed moreover, this section proposes that the offense under this section is cognizable, non-bailable, and non-compoundable. So that means that FIA can arrest any person without any warrant, and he might not have the right to bail as well. Then we have e-safety bill. Surprisingly, the draft of this bill has not been made public, and neither any consultations have been made with the experts in the field, and nor they have taken any suggestions from the relevant activists or lawyers, we can say. And then, as it is written, that this bill has been introduced with the intention to prevent cyberbullying and harassment. But we know that already there is a bill in place, that is PECA, and all of these offenses like cyberbullying and harassment have their places in that bill. So it might become redundant as well. Another serious problem with this act, with this bill actually, is that this bill requires the registration of social networking sites like YouTube, Netflix, Amazon Prime, etc., to be registered under e-safety authority. So this regulatory model can drive these networking platforms out, because for instance, if there is an ordinary blogger who wants to upload a certain video on his channel or any of the social media platforms, he will have to register first under the regulatory authority, and then he will be able to upload his content. So that might become very hectic for anyone to upload his content on any of the channels. And then most importantly,
Fahad, I have a
yeah.
question. I have a question. Is there any example around the world where these social media platforms have been regulated as they are, in this proposed legislation?
So right now, I think Amira and Henson were covering the international context, so they will be able to guide better. But as far as the registration is concerned under the e-safety authority, that is hectic, right? So, for instance, I am uploading any of my content on YouTube or anything like that. So there is no restriction on me, right? But after this bill is in place, so that will obviously become hectic for anyone to upload his content, right? And then lastly, we have the most important of these bills, that is the personal data protection bill. Surprisingly, the government or the drafters of this bill have received feedback and suggestions from the experts of the relevant field, but the suggestions and the feedback that they received from these experts has not been incorporated into the act. So they didn't pay any heed to any of these suggestions, and the bill was passed hastily in the federal cabinet. The main problem with this bill is its section 31(2), which states that which requires the data localization. So what is data localization? It means that the data of the users will only be processed within the territory of Pakistan. So what implications this can have on our trade? So if our data is just locked up in one place and it is not available internationally, that means that our international trade will be hindered, as there will be no foreign investment in Pakistan.
Hello? Hello?
Hello.
Yes, I can hear you.
Okay, thank you. My name is Ehtisham ul Haq. I am currently a final year student of Khyber Law College, University of Peshawar, and currently I am research assistant in RCIL. So I will explore the legality of e-safety and personal data protection bill under Pakistan law, which is a complex issue, I believe. However, there are certain provisions such as Article 4 emphasizes the significance of adhering to legal procedures and due process. The bills protect individuals' digital dignity by combating cyberbullying and harassment and the misuse of personal data. Article 19 protects free expression while allowing reasonable restrictions to protect national integrity. And Article 19 emphasizes reasonable information sharing, while Article 20 establishes safeguards for digital privacy. Article 25 ensures that all individuals are subject to the same rules, and Article 37 promotes social justice and the abolition of social evils. So let's move towards the constitution analysis of these bills. The e-safety and personal data protection bill might face challenges due to potential violation of constitutional rights. The e-safety bill could be questioned for potentially infringing on Article 19, which is freedom of speech by giving the power to government to censor online contents. Past incidents like journalists retracting statement due to the PECA 2016 have raised some concerns about the freedom of speech, whereas petitions have been filed concerning these issues. We have some petition from the past. In 2017, journalist Taha Siddiqui filed a petition, red petition number 1956, 2017, against FIA intimidation on May 27, 2017. He was called for questioning about his opinions and journalism by an FIA officer without a proper authority. Islamabad High Court intervened and restraining FIA harassment and instructing lawful proceedings. Despite court orders, FIA issued a summon threatening legal action if Siddiqui didn't comply. So we have another petition. On June 7, 2017, 9 citizens submitted petition to the Sindh High Court against the Ministry of Interior and FIA. They challenged the detention of activists and journalists under the PECA 2016. The petitioners argued FIA action violated due process and fundamental rights. They claimed criticizing the armed forces wasn't a crime and didn't fall under Article 19 exceptions. The petitioner accused the government and FIA of suppressing free speech and obstructing citizens' rights to constructive criticism under Article 19. The PECA 2016 was criticized for violating these fundamental rights, and similar concerns can be detected in the recent bills, the e-safety and personal data protection bill. That's all from my side. Now I will hand over the mic to the Amir of Rashid for international law perspectives. Thank you.
Thank you, Itham.
Welcome, sir.
Am I audible?
Yes, you are.
Yes.
Good afternoon, everyone. My name is Amira Rashid, and I, along with Henson, will be discussing the legality of the bills under international law. So, as Fahad and Ehtisham already analyzed the bills, that what are they about and what are the sections which have been amended in these bills. So I will be discussing them one by one. So firstly, there is PECA Amendment Bill. The new sections which I will be discussing under this, which needs attention under national law, are Section 37 and Section 37A, which allows PTA, which is Pakistan Telecommunication Authority, which is the regulatory authority, which actually regulates the social media as well as the television content in Pakistan. So it allows Pakistan Telecommunication Authority to block or remove the content, even the whole social media companies. So it is really concerning that this particular section gives a lot of authority to PTA that they can remove or block even the whole social media company. So we can see that the right to freedom of expression and right to freedom of speech and opinion is badly affecting here. So Pakistan is a signatory of UDHR, which is Universal Declaration of Human Rights, as well as ICCPR, which is International Covenant on Civil and Political Rights. So Article 19 of UDHR provides freedom of opinion expression, as well as Article 19 of ICCPR also provides everyone that they have the right to hold opinion without any arbitrary interference. So when we analyze these sections under these provisions of international law, so if PTA has a very wide range of powers that they can remove any kind of content which they seem unfit, so it badly affects the right to freedom of expression and right to freedom of speech of citizens of Pakistan, because they will not be allowed to hold their opinions freely, and they will not be able to write anything they
Hello? Is Amira there?
No, sir, she left, sir.
I'm so sorry for the fluctuation. I think my internet got disconnecting. Am I audible?
Yes, yes, you are. Hello?
I'm so sorry, everyone. So I was stating
Amira,
that there are
I have a
also
question for you.
regional.
I have a question for you concerning Section 37 of PTA. I think it's Section 37 of PECA.
Yes, sir.
Yeah. So it allows PTA to block, remove the content, even the
Yes,
whole social media company.
sir.
What do you mean by removing the whole social media company?
So, for example, if I have a social media, I have a social media company, or or maybe if I have a company and I have a website on internet, and maybe I um, publish articles on that. So if PTA deems, and if I, for example, post content which PTA deems unfit, maybe I post content against working of judiciary or working of military, and PTA thinks that it is against its policies, so they can actually delete my whole website from internet. They can actually block that website. It will not be able to post content.
Okay, I understand.
Sir, can I move forward?
Yes, yes, please.
Thank you, sir. So the second bill which has been discussed by Fahad and Ihtisham is e-safety bill 2023. So as Fahad already told, that e-safety bill requires that there would be registration of websites, web channels, YouTube channels, and also existing media houses and their websites. Under this e-safety bill, obviously there would be authority, which will be the e-safety authority, which will be responsible for registration of all of these websites. So as sir asked the question, that is there any other country where the websites are being registered? So as far as I have researched, there are no countries which actually have made such authorities, which will that the authorities which register the website, they are registered under copyrights or maybe trademarks, and under such kind of conventions such as WIPO, because the website content is actually copyrighted, that you cannot maybe copy the content of other people. But there is no regulatory authority which actually regulates the content on the websites in other countries as well. I have not seen any jurisdiction doing so, because it actually makes it very crucial for people to post content. It makes it very difficult to post content, because if everything needs to be regulated, and if people would not be able to hold their opinions freely, how will they use social media? How will they use their personal maybe accounts and all of that stuff? So under this e-safety bill, it is really crucial to discuss that if people, the e-safety authority, which will be regulating the websites, it will also have the authority to remove the websites and remove the content which they deem unfit. So it actually it actually suppresses the right to freedom of speech and right to freedom of expression and holding opinions, just like PECA Amendment Bill 2023. The last bill which I'll be discussing is Personal Data Protection Bill 2023, and it actually is really crucial because it talks about personal sensitive data. So under this, the clause which is really concerning is that the the bill says that there should be data localization where companies are being forced to open data centers in Pakistan and process critical personal data. For example, if I have a company in maybe UK and I want data of Pakistan, the people of Pakistan. So I should make my data centers in Pakistan to gather data of Pakistani citizens. So it is also very important what kind of companies will be coming in Pakistan and what kind of rules and regulations they will be following. And also, there's a requirement that if the companies want to have the data after making their data centers in Pakistan, they have to share the sensitive personal data which they're collecting with the government of Pakistan. And the act actually does not really qualifies what is a critical and sensitive data. It provides a wide definition. So it is really crucial to discuss that in this way, the privacy and private data and personal data of the citizens of Pakistan is at stake, because Article 12 of UDHR, Article 17 of ICCPR, it provides that everyone has the right for protection of privacy, family, home, or correspondence, and there should be no arbitrary interference by the government and by any other state actors.
Amira,
And
isn't this law of personal data protection, of localization of data centers, isn't it for protection of private data and preventing the foreign companies from accessing that private data and using it illegally?
yes, sir, there is a point that if foreign companies are using that data, then the government of Pakistan will have their maybe check on the data which they are using. But that those governments will have to share, so those data centers will have to share the data with the government of Pakistan. But there is no specific maybe procedure or method given that what kind of data they will be, because the definition is very wide, and for what purpose they will be utilizing that personal sensitive data. So if there is a foreign company which is using my data and it is giving the data to government of Pakistan, so I will not be able to know for what purpose government will be using my data. So my privacy is at stake. I'm analyzing it from that point of view.
Okay, please continue.
Sir, can I move forward?
Yes.
Thank you, sir. So the last point which I want to discuss is that how a general comment by the United Nations Human Rights Committee. It is general comment number 16 on Article 17 of ICCPR, which is related to protection of privacy. So under this comment, I want to highlight it with the aspect of cyber laws and cybersecurity. So this comments actually advises the state parties, which are parties to ICCPR, and Pakistan is a state party. They advise that if any state party or any state actor is using the data of the citizens of individuals, it should not be authorized in a way that it is used for any purpose. So if the data is for maybe for the purpose of public safety, or for maybe for the interest of the society, or maybe in the interest of the state, then the data can be the personal data can actually be used. And it also advises the state parties that in order to protect the private life, every individual should have the right to ascertain in an intangible form that what kind of personal data is going to be stored in automated data files. For example, if I have my data on a website, so if if a social media company or any company utilizes my data, so for what purpose they will be utilizing my data, I should know about it. And what kind of data they will be picking out from that website, I should know about it, because I have the right to privacy. And if anybody, any state party, any state organ, any company, or any regulatory authority just comes up and takes any of my personal data without notifying me, and without notifying me for what purpose they are actually taking out my personal data, then it will be crucial to protect my personal property and my personal opinions or my privacy. That's all. Thank you.
Yeah, thank you, Meera. Henson, you can continue.
Sure, no problem. So in my case, I consider it as a some of the supplementary information for Amina's part, simply because in our discussion today, of course, we are going to take a look at the PECA Amendment Bill 2023, the E-Safety Bill 2023. So in this case, it seems we may focus a lot on the Universal Declaration on Human Rights and also the ICCPR. And as all of you may be aware, besides these two international treaties, we also take a look at some regional treaties like the African Charter on Human Rights and also the European Convention on Human Rights. So in this case, I would like to point out several statutes that all of us should bear in mind, because looks like those statutes in the ICCPR and also the Universal Declaration of Human Rights, simply they are provide rather brief guidelines. They have versatile points to ensure that all individuals worldwide, especially when Pakistani government also signed those treaties, they ratified the treaties, that means that they should always comply with the law. But in this case, I would like to draw your attention to the International Covenant on Civil and Political Rights, Article 4, and in some remarks in Article 5 too, simply because when we talk about the collection of data, we talk about the censorship. So when we need to strike a balance with that, so the Pakistani government will probably try to use some of the concerns related to public emergency, that if we take a look at Article 4, so it's stated in time of public emergency, which threatens the life, nation, and also the existence, which is officially proclaimed, the state party to the present covenant may take measures to derogating from the obligations under the present covenant to the extent strictly required by the exercise of the situation. So they may have some obligation under international law to intervene in the internet and then try to block some of the websites, some of the channels on social media. So sometimes the government may have the possibility to justify their action. And of course, in this case, when we talk about Article 19 of ICCPR, once again, in particular 3A and B, they may have some necessary measures that requires the government to take action to show the respect of the rights, reputation of others, and if they need to talk about something related to the protection of national security or of public order, public health, morals, that they may have the justification to do so. And in Article 20, any propaganda for war should be prohibited by law, and any advocacy of national, racial, religious hatred that constitute incitement to discrimination, hostility, or violence should be prohibited by law. So in this case, I think when we need to conduct our research and further, that we may include some of the statute here to ensure that we have to strike a balance. We need to take a look at the statute to ensure that unless those censorship related to issues aforementioned, otherwise they should not be banned. And I'm sorry, my apologies. Looks like I missed one point when Article 37.1, when we talk about recording and storing of national data on convicted sexual offenders, that they may have some of the regulations as well. And one thing I will like to draw your attention, it's the General Data Protection Regulation, the GDPR 2018, even though it is the regulation under the EU law, it is based on the European Convention on Human Rights, Article 8. That means that the institute itself has the right to respect private and family life. They, in their Article 5.1 and 2, indeed, they list out 7 data protection principles. So if we need to set up any statutes, if we need to talk about whether we should implement some of the sensation measures regarding some social media, that we have to consider the lawfulness, fairness, transparency, the purpose, limitation. That means you must process data for legitimate purposes when you collected it, and you also need to minimize your data. That means you only collect or process only as much data as absolutely necessary for the purposes specified. They should be accurate. And if you need to minimize the data that you collect, you should also limit the storage of storing these data. You need to comply with the principle of integrity, confidentiality. That means the processing must be done in such a way to ensure that appropriate security, and of course, you have to be accountable, that you have to demonstrate the compliance to the GDPR. And lastly, when we talk about if you need to process the data, you need to follow Article 6, just what I've mentioned. They list the instance that which is legal to process personal data. So no collection, storage, and sale to advertiser are permitted unless one of the following conditions can be justified. So actually, it is some of them have been repeated. It is related to the ICCPR. It's also related to the European Convention of Human Rights. What I would like to say is we must focus on several key terms. Let's say we have to be specific. We need to have the ambiguous consent to process the data. We need to consider the necessity. We have to consider what are the legal obligations we have. Well, when we talk about the public interest, when we talk about the official function, legitimate interest, etc., then in this case, we have to consider all these factors to ensure that if we set up a certain statute, will they violate some of the principles listed here, even though the GDPR is a law, it is a regulation under the European Convention, but the reason why I think it is necessary for to bring this to our discussion is because this convention is not limited to member states of the European Union. It is not talking about the rights and obligations among EU citizens, but instead when the Pakistani, no matter the government, no matter the people, if they have some encounters to European companies or other ordinary individuals in the European Union, that it seems, besides taking a look at the statute law, to take a look at the statute itself, it is also important to ensure that the statute itself is complied with the European and international.
Yes, thank you, Hanson, for that very informative and insightful presentation. Okay, I think we are out of time as well. Thank you, everyone, for your participation and wonderful presentations. And I look forward to meeting all of you next time. Thank you.